Now, with regard to the bill that's presently before us, this recurrent bill, Acting President, asks it's the government, executive government, asking Parliament to approve an appropriation which includes more than $1.8 billion for the Department of Communities. Now, members will be aware that that child protection is housed within this mega department, and members will be aware that I have previously been very critical and continue to be very critical of the government's decision to amalgamate child protection, which used to be a standalone government department, into this mega department of communities, completely at odds with the report that was done by Prudence Ford now some 20 years ago, which led to the establishment of a standalone Department of Child Protection. It's not new to members that I have been critical and continue to be critical of that particular matter. But the question that I have this afternoon, Acting President, is what confidence can we have that the money, that is, this more than $1.8 billion that's going to be delivered to the Department of Communities, which includes the Child Protection Agency, what confidence can we have that this money is being administered under competent governance? Now, in my view, Acting President, one recent case provides this House with the opportunity to answer that very question. Now, the case, Acting President, is the case of JAH and ADH and the CEO of the Department of Communities. It's a judgment that was delivered by Magistrate Goiran in the Children's Court on the 5th of June 2026. 5th of June 2026. Now, those who are paying attention will note that I did deliver a budget speech on the motion 4 days later on the 9th of June 2026. The significant development that has occurred since then, Acting President, took place during the budget estimates hearings, and we had the Department of Child Protection in on the 24th of June 2026, and we're going to get to that in a moment. Now, keep in mind, Acting President and members, that this judgment, which I have in my possession here, which was delivered on the 5th of June 2026, is only the second written judgment in the Children's Court this year, as at that time, the 5th of June. When I last looked, I think a few days ago, or was it last week, there has been a third written judgment since then. But as at that time in June, and certainly as at the time that we had the budget estimates hearings in late June, there had only been 2 written judgments in the Children's Court up until that particular point. And it's my proposition to members this afternoon, Acting President, that Parliament should pay attention whenever a judicial officer, in this instance a magistrate of the Children's Court, publishes detailed reasons concerning the department entrusted with protecting children. Now, I'm going to spend some time this afternoon, Acting President, quoting from the judgment delivered by Magistrate Goiran. I do note that earlier this afternoon, in question time in the other place, there was repeated commentary by the Minister for Child Protection, pushing back to the member for VAS about the characterisation of this judgment as scathing. Now, it's the position of the opposition that the judgment is a scathing judgment. The Magistrate Goiran has been scathing of the department's handling in respect to this matter. And it's up to the Minister. Of course, she's entitled to push back on that. But very interestingly, in a supplementary answer to a question this afternoon, Acting President, it became apparent that the Minister has not read this judgment in full. Now, I'm grateful, Acting President, that my learned friend, the Honourable Pierre Yang, is in the chamber this afternoon, and I note that during the winter recess he has been appointed as the Parliamentary Secretary to the Minister for Child Protection, and I say most sincerely to my learned friend that this is a court judgment worth reading. It's worth reading and being across and for the reasons that will become obvious in a moment. Now, in very brief summary terms, Acting President, this judgment relates to a now 7-year-old boy. He was 4 months of age when he was taken into care. In fact, I'm going to stop there just for a moment, Acting President, because I've already given members in this chamber some information about this boy. Now, if members were to listen to the Minister for Child Protection, you would be forgiven for thinking that we're not allowed to talk about this case. Because, Acting President, both the Department and the Minister, their trite responses to media inquiries in respect to this matter have been the usual defence to say we don't talk about individual cases, and that was essentially the Minister's response repeatedly to the member for Vass this afternoon. We don't talk about individual cases. Well, somebody perhaps might do the job of contacting the Minister for Child Protection, putting this judgment in front of her, given that it's in respect to her department and her agency, and saying, would you like to talk about this? How absurd it is to suggest that we can't talk about individual cases when a court within our own jurisdiction has done exactly that. Are we seriously trying to suggest that we're not allowed to talk about this court case? So I return to the facts of this case, Acting President. This particular boy, who is now 7 years of age, was 4 months, a very young infant, when he first came into care. It's not disputed by anybody that this particular boy has profound medical complexity. Again, I'm going to pause, Acting President, because I'm going to be talking about personal facts in respect to this particular boy. It's on the public record. It is in this judgment, which is publicly accessible by anybody. Now, it should be noted that quite appropriately, the court judgment de-identifies the individuals. The names of the individuals are not in the court judgment, and that is quite right. And the problem we have, Acting President, is we've got a minister who misunderstands the difference between identifying a particular individual and talking about a case. We're not going to see any improvements ever, Acting President, in the child protection system in Western Australia if we're going to have a minister who's the chief person responsible for this system who's not even prepared to talk about an individual case. No one's asking her to identify individuals, but we are asking her to consider individual cases, and in particular, when there's a scathing judgment from a magistrate, what improvements should be made. Now, as I say, Acting President, 7-year-old boy, first taken into care at 4 months of age. Now, the foster carers in this judgment, Acting President, this is the determination of the magistrate. The magistrate describes the foster carers as diligent, loving and adept, and also says in the judgment that after nearly 7 years in care, remember this young boy has come into their care at 4 months of age, and now at the age of 7, this is the point where that we are at, and throughout that period of time, from 4 months of age to 7, he has been in their care, and it should surprise nobody that he refers to these two foster parents as mum and dad. So I'm asking members this afternoon to contemplate for a moment the scenario of a 7-year-old boy who essentially for the entirety of his life, yes, not for the first 4 months, but other than that, certainly for all of the time that he can remember, because which of us can remember the first 4 months of our life, for that period of time, he has been with this particular foster family. Now, and I'll get into the judgment in a moment, Acting President, it is the case that at one stage the boy's grandmother comes forward. Now, I want to hasten to say this, Acting President, so that nobody mischaracterises my comments this afternoon. I have nothing but positive things to say about the grandmother. I've never met this person before in my life, but from everything that I read in this judgment, it seems to me like what I would expect of any caring grandmother. This is a grandmother who clearly cares for this particular young boy and wants to reunite her family. And so I have nothing but positive things to say in respect to what I can read from this particular judgment, as I do in respect to these two foster parents who have looked after this young boy for the best part of 7 years. Now, relevantly, Acting President, the department has opposed this application. You see, this judgment that's been handed down by Magistrate Horrigan, again, I might note in passing, Acting President, that Magistrate Horrigan is a very experienced magistrate in the Children's Court. This is not somebody who's just been there for the last 5 minutes. This is a very experienced magistrate specialising in these child protection proceedings. Now, the department has opposed this application that's been made by the foster parents. They wanted a special guardianship order to say that this boy should be under their care and protection, that they should be appointed as guardians until such time as he turns 18. And it's left to the court to make this difficult decision. Again, I want to hasten to add here, Acting President, so that my comments are not mischaracterised, particularly by members in the other place who have a propensity to do those type of things. The opposition is not quarrelling with the magistrate's decision or making any aspersions in respect to either the foster parents or the grandmother. But we've got a lot to say, Acting President. We've got a lot to say about the department's handling of this matter, both prior to this judgment and since, and also the attitude of the minister since then. Now, Acting President, I will quote from the judgment momentarily, but as is evident, the foster parents' application was ultimately dismissed with essentially an order or recommendation that the young boy be transitioned into the care of the grandmother. And so I'll take a few moments now, Acting President, to quote from the decision, which reads as follows, and I'll obviously provide the judgment to Hansard for their use. At paragraph 1 it says, this hearing is about KJA, a medically complex 7-year-old child of South Sudanese heritage, placed with Caucasian Australian carers, JAH, and her husband, ADH, since he was 4 months old. A protection order until 18 was granted on 7 August 2024. The order gives the Chief Executive Officer of the Department of Communities parental responsibility for KJA to the exclusion of any other person. Later, at paragraph 3, the magistrate says, on the 28th of October 2024, the carers lodged an application pursuant to section 69A of the Act seeking that the court revoke the protection order until 18 and replace it with a protection order, special guardianship in their favour, with an order for payments as per section 65 of the Act and contact arrangements. If granted, the carers would then have parental responsibility for KJA to the exclusion of any other person until he turns 18 years, subject to another application being made. Later at paragraph 10, the magistrate says, the issue for determining is whether I should grant the special guardianship application dated the 19th of February 2026 or not grant the application and maintain the status quo which exists under the current order. This exercise required me to examine the trial evidence, assess what would be in KJA's best interest and consider section 61.2 and section 61.2AB of the Act. My decision will determine who KJA's guardian will be. Now, later, Acting President, at paragraph 17, the magistrate sets out the department's position. Remember, this is the department that we are being asked to fund to the tune of more than $1.8 billion. The department's position is set out at paragraph 17, which says the department opposed the special guardianship application. Paragraph 19, it says the department remains committed to the plan to transition KJA to NK's care as they have assessed NK to be an approved carer. Now, for those people who are not aware, NK is the maternal grandmother. This is the boy's grandmother that is being referred to here. And again, we're not being critical, Acting President, of the idea or the goal of reunification with the family of origin. Paragraph 20 says the department's plan includes KJA maintaining his relationship with the carers and their family. Now, Acting President, if members remember nothing else about this case this afternoon, I would ask them to remember that Paragraph 20 in the judgment says the department's plan, that's the Department of Communities, the department's plan includes KJA, that's this 7-year-old boy, maintaining his relationship with the carers and their family. That's the foster carers. That's this husband and wife who have been looking after this boy for the best part of 7 years, and according to the judgment, the department's own plan is that he should maintain his relationship with these foster carers. And I'll explain a little bit later, Acting President, what the current state of affairs is with regard to the relationship with the foster carers. Now, the judgment then at paragraph 21, Acting President, goes on to talk about, as people would perhaps imagine, the boy's mother. Because where in all of this is the boy's mother? We've talked about the foster parents and we've talked about the maternal grandmother. Well, where is the mother? Well, at paragraph 21 it says AMA lives in Brisbane, Queensland with her 4th child, EA, who is KJA's 3rd brother. At paragraph 22 later it says duty counsel, that is, a lawyer who's been appointed to represent the mother. Duty counsel represented her at the commencement of the hearing to advise the court that she opposed the protection order special guardianship. So keep in mind that at the beginning of these proceedings, the mother of this young boy opposes the application by the foster parents that they be the special guardian. It goes on at paragraph 23 to say, AMA supported the department's plan that her mother care for KJA. NK cares for AMA's sons, DA born on the 25th of October 2012 and GA born on 1 February 2014. Under a family arrangement, her long-term goal is to be reunited with KJA. In other words, the mum at this point in time is saying that she's happy for this 7-year-old boy to go and live with her mother, that is the grandmother, because she has 2 of her other children also being looked after by the grandmother. And so perhaps people can understand now the circumstances that are arising here. Perhaps that's not all that unusual. And she, the mother, is saying through her counsel in this court decision that her long-term goal is to be reunited with her son. Now, interestingly and relevantly, Acting President, at paragraph 25, the magistrate reports this. On the 6th day of trial, the same duty counsel who previously assisted AMA advised by email that AMA's position had changed. Quote, she now consents to the SGO application. She does not wish to participate further in the trial process. So by the 6th day of trial, the mum of this boy has said she consents to the application that this boy go and live with these foster parents whom he has been living with for essentially all of his life. The judgment then goes on at paragraph 26, Acting President, to set out the position of the grandmother. The grandmother is said at paragraph 26, NK opposed the application for special guardianship. NK cares for 2 of her children and 3 of her grandchildren and seeks to have KJA transition into her care. I again hasten to add, Acting President, there is no critical comment by the opposition in respect to that. That sounds to me like a perfectly natural and appropriate response from a grandmother who cares about her grandson. Then at paragraph 28, the court records the separate representative's position. Now, members may ask, what is a separate representative? A separate representative is essentially a lawyer who has been appointed to speak on behalf of the child into the proceedings. And at paragraph 28, it says, the separate representative supported the revocation of the current protection order and replacing it with a protection order, special guardianship, in favour of JAH and ADH, with specified contact conditions which could be registered in the Family Court of Western Australia pursuant to Rule 477 of the Family Court Rules 2021 to ensure enforceability. Translation: the separate representative supports the foster parents. Now, this is the person that's been appointed by the court to represent this young boy. Paragraph 29. Her view was based on several factors. Firstly, KJA's medical needs are significant and those needs are met by the carers. Secondly, KJA is emotionally secure with the carers, having been in his placement for 7 years, and his primary attachment is within that placement. Last, specific contact arrangements would provide for and maintain familial and cultural connection. Acting President, later in the judgment at paragraph 40, the magistrate says, in April 2022, NK underwent a carer assessment. Remember, NK is the grandmother. Although she did not meet the requisite criteria, the department arranged for NK and the maternal family to commence supervised visits with KJA. So there's going to be this interaction with the young boy, but it's going to be supervised. Paragraph 41. NK continued to work with the department with a view to being approved as KJA's carer. On 23 May 2024, an interim placement and carer assessment approved her as a carer for KJA with supports despite not meeting all the carer competencies. Now, this is a theme that continues to emerge throughout this judgment, Acting President, that the maternal grandmother is clearly keen for this arrangement to take place. She wants to look after her grandson, but seems to consistently not meet all of the carer competencies. So she's able to do some of the things, apparently, but not do all of the things, and members should keep that in mind as they are considering this decision. Paragraph 42. When the interim placement and carer assessment was undertaken, the parenting capacity assessment of Lisa Dominguez, clinical psychologist, Mind State Psychology, dated 14 November 2023, was available to the department. Ms Dominguez had been appointed the court expert on 20 October 2022 and provided 2 subsequent reports. Ms Dominguez's conclusion as to NK's capacity to care for KJA was not a positive assessment. So, Acting President, we've got a new player that's now introduced into this judgment. We've got this clinical psychologist who has been appointed as a court expert, and she is critical or not positive of the grandmother's capacity to care for her grandson. Later in the judgment, Acting President, paragraph 60, Ms Dominguez, that's the clinical psychologist, it's reported here saying, concluded, however, that NK would not be suitable to be KJA's carer, even with a raft of services provided by the department. She found that NK minimised KJA's medical health needs and did not understand the intricacies of those needs. Because of NK's cognitive functioning, she was concerned that NK would not understand and manage KJA's medical health needs consistently and proactively, and NK would find managing KJA's specialised needs too demanding, placing a burden on the other children she cared for. Ms Dominguez found that as a result of KJA's secure attachment to his carers and because of his vulnerabilities, he would find a transition overwhelming with negative implications in the shorter term, with lasting effects on his longer term outcomes. She added that the lack of closeness to NK would also make the transition more challenging for him. On this point, unlike the carers who had cared for KJA since he was 4 months of age, NK's contact started in 2022 and had only become semi-supervised at her home in 2023. Now, Acting President, later in the judgment, yet another player emerges in these particular proceedings. Paragraph 76 says, on 7 August 2025, Summer McAvoy, Specialist Community Child Protection Worker, completed the carer review for NK. The review found that NK met the carer competencies. Ms McAvoy did not review the November parenting capacity assessment from Ms Dominguez despite having access to the departmental file. So, Acting President, we have this new player that's emerged, this Specialist Community Child Protection Worker. This particular individual suddenly says that the grandmother does meet the carer competencies, but it's clear hasn't reviewed the previous information on the departmental file. Now, Acting President, I say once and again, the opposition's not critical of the foster parents. We're not critical of the grandmother who clearly wants to have this reunification with her grandson. But is it appropriate for us to be critical of the department when you have a Specialist Community Child Protection Worker who's making an assessment but hasn't looked at the previous information on the file? Is that the standard that we are expecting for child protection now in Western Australia? $1.8 billion is going to the Department of Communities in this budget, more than $1.8 billion. I expect, and I imagine I'm not the only one, that if there's a child protection worker making these kind of assessments, they will look at the other information on the file, particularly when there is a clinical psychologist that has raised multiple concerns in respect to the carer capacity of an individual. It goes on, paragraph 78, Acting President. Ms Dominguez, now remember this is the clinical psychologist, provided a second report dated the 25th of January 2026 and an accredited interpreter attended the interview. In broad terms, the report again concluded that KJA's psychological, emotional, social and intellectual wellbeing would be best supported in his placement with the carers. Ms Dominguez expressed concerns about NK's understanding of KJA's medical needs, repeated minimisation of those needs, which was disputed by NK, and despite an increased relationship with KJA, NK and the maternal family, her view was that KJA's primary attachment was with the carers. She acknowledged that NK and the extended family provided an important source of cultural connection for KJA and that NK is well placed to support his cultural identity through ongoing contact. The relationships with the maternal family were best understood as important relational and cultural connections that complement rather than replace his primary attachment relationships." End quote. Acting President, members can see here a pattern emerging. Nobody is suggesting that this young boy, who's 7 years of age, should have no connection, no contact with his grandmother. Equally, nobody is suggesting that he should not have any continuing contact with the foster parents whom he refers to as mum and dad, having lived with them for basically all of his 7-year life. Now, Acting President, at paragraph 84, it goes on to say, in this regard, Ms Dominguez promoted the continuation of KJA's placement with the carers under a special guardianship arrangement, as KJA's developmental need would be best achieved by stability in his placement. Ms Dominguez noted he has lived with the carers since infancy and presents with neurodevelopmental vulnerability including FASD, intellectual impairment, attachment-related anxiety and complex medical needs. Disruption of his primary caregiving arrangement, especially given his developmental immaturity and established attachment reliance on the carers, would pose a substantial risk of emotional destabilisation, behavioural dysregulation and regression across multiple domains of functioning. While KJA's cultural identity and connection to his maternal family are important for his long-term development, cultural safeguarding must occur within a stable primary attachment framework. Stability is the foundation upon which cultural identity can be meaningfully supported." End quote. So, Acting President, yet again, we have here the clinical psychologist telling the court that we have a 7-year-old boy with significant medical complexities who's in a stable home with these foster carers, and that, yes, the connection with culture and the family of origin is important, but balancing those things, on the whole, the boy should stay with the foster parents. That's essentially what the clinical psychologist is saying. Now, Acting President, later in the judgment, the magistrate says this in respect to the placement with the carers. So this is effectively the magistrate who's considered all of the evidence. This is her determination with regards to these foster parents who have been looking after this boy for basically the whole of his 7-year life. Magistrate Horrigan says at paragraph 106, KJA's carers are dedicated to him, diligent, loving and adept in their carer role. Not surprisingly, he calls them mum and dad. They have known and cared for KJA since he was a baby, so their knowledge of him is extensive. They are acutely aware of his needs, his diagnosis and his frailties, given the long-standing nature of their care role. Given JAH and ADH, that's the foster mum and dad, experience, it is understandable why key assets placed KJA into their care, and I find that they are competent foster carers. Now, Acting President, I'm going to pause for a moment while I'm looking at this judgment to let members know that the current state of affairs is that this foster family, this foster mum and this foster dad, remember the magistrate has just said that they are competent foster carers, and a piece of information I haven't not yet shared is that they have looked after many foster children in Western Australia, many. I think the number's 14, but I stand to be corrected on that. It's a significant number. They are never going to do this ever again. After this experience, they have said, we're never doing this ever again. That's why this is significant. That's why the Minister for Child Protection needs to read, not parts of this, Minister. The Minister needs to read all of the judgment. That's why the Minister needs to get to the bottom of this and talk about an individual case. Not about individual people, not identifying them, but something needs to be done about this. Because as a result of this, we have $1.8 billion of taxpayers' money, more than that, going to this Department of Communities. And as a result of this case and the deficiencies within the department, we have caring, loving, adept, diligent, competent foster carers saying never again, we're not going to do this anymore. Now, Acting President, later in respect to culture, and in particular the maternal grandmother, the magistrate says this at 135. This is in respect to the grandmother, her evidence was that in South Sudanese culture, the community is actively involved in raising a child. She firmly believes that KJA's prolonged exclusion from the family is harmful to his future, risks cultural disconnection and precludes everyday socialisation and nurturing. She believes that his time to understand the importance of culture in his life must happen between now and when he is 18. I find it very difficult to quibble with that, Acting President. It makes perfect sense to me, and I can understand why it made perfect sense to the magistrate. Now comes the magistrate's comments about the department. And I want members to understand that earlier this afternoon, the Minister for Child Protection tried to tell the member for VAS that this is not a scathing judgment. Now, I've got no confidence with respect to that characterisation by the Minister, given that by her own admission she hasn't even read the judgment in full. This is what it says at paragraph 139. I find that the department's cultural plans contained in KJA's care plans were inadequate and largely meaningless rhetoric. What else would the Minister for Child Protection like the magistrate to use? What other language would she like the magistrate to use that would be considered to be scathing? The department's cultural plans were inadequate and largely meaningless rhetoric. I would describe that, Acting President, sorry to have to paraphrase here, but I would say that this is the magistrate saying that the cultural plans were rubbish. There's probably stronger language that could be used, and it would be unparliamentary. But they were inadequate and largely meaningless rhetoric. In other words, they were rubbish. Goes on at 140. They contained motherhood statements and hopes with no active plan to enrich and develop KJA's cultural knowledge and experiences. This is despite NK living in Perth since early 2020 and contacting the department in February 2020. At the very least, a culturally appropriate contact arrangement could have been developed to encompass the whole family, especially the sibling relationships. Somebody needs to draw this to the Minister for Child Protection's attention. She seems to think this is not scathing, but she hasn't read all of the decision. How about the Minister, if she can't read the whole thing, just read paragraphs 139 and 140. At this point in time, there's only 3 judgments in the Children's Court so far this year. I think the Minister for Child Protection should read all 3. But if that's asking too much, can she just read 2 paragraphs, 139 and 140, and then maybe comment on that? At 146, this is the magistrate saying what a cultural support plan should look like. She says, a cultural support plan, as opposed to a care plan, is intended to develop, deepen and maintain a child's cultural identity by promoting the child's cultural, ethnic and religious identity, as well as developing and maintaining connection with the culture and traditions of the child's family and community. They should ensure that planning decisions are made with an appropriate cultural lens. Only one cultural plan was filed during these proceedings, the cultural plan dated 23 May 2024. That plan confirmed that at 5 years of age, KJA had limited understanding of or exposure to his South Sudanese heritage and culture. This was the most important cultural document filed during these proceedings, and it only scraped the surface of KJA's culture in a superficial manner. Whose fault is that? Whose fault is it that after all has been said and done, there's only one cultural document that's been filed in these proceedings, and the best that the magistrate can say about the department's work is that it scraped the surface of this boy's culture in a superficial manner? Scathing judgment? I think so, Acting President. Now, paragraph 168, the magistrate says, I am satisfied that NK and the maternal family are best placed to promote KJA's culture. On this issue, the carers would agree. I think every fair-minded person would understand that. The person who is going to be best placed to promote this young boy's culture is the maternal grandmother and the maternal family. Now, Acting President, it's regrettable that time doesn't permit me to quote more extensively from the judgment, but I do want to quote a few more paragraphs before making some concluding remarks. At paragraph 211, the magistrate says, now this is in respect to the issue of a transition. She says, I find that upheaval will be managed best if planning occurs in a sensitive manner consistent with KJA's needs. In other words, Acting President, there's been all this other evidence before the court. Not surprisingly, the evidence is that a transition is going to be difficult for the child, but there's also this recognition from the magistrate that a transition in these circumstances, remember a boy who only knows really this foster parents as his family for 7 years, he's lived with them, that a transition to another carer, albeit the maternal grandmother, is going to be difficult, and there's this recognition by the magistrate to say that it would be difficult for anybody, and so that would not be particularly unusual in this situation. But the magistrate says, I find that upheaval will be managed best if planning occurs in a sensitive manner consistent with KJA's needs, and I'd ask members to remember that. Planning that would occur in a sensitive manner. Unlike Ms Rachel Cloessi's evidence, which suggested that the transition had to happen sooner rather than later, I consider that JAH's initial concerns were valid. A gentle approach to transitioning KJA to NK's care should be undertaken using the school holidays to lengthen the time he spends in NK's care and respecting input from JAH. So translation here, Acting President, is that the magistrate is already sort of indicating that there's going to be this transition to the maternal grandmother, which is what the department's view has been, but that transition is going to need to be a gentle approach, and it should be undertaken using school holidays to lengthen the time that this boy spends with his maternal grandmother. Sensitive, planning, gentle approach, transitioning, using school holidays. Guess what happens, members? Guess what happens? This decision's on the 5th of June. Within a week, this boy is taken from the foster carers and placed with the maternal grandmother. Remember, the decision's the 5th of June. So within a week. So it's happened by the 12th of June. He's been taken from these foster parents. He's lived with them his whole life. He's taken from them. He goes and lives with the maternal grandmother. Within a week, that's by the 12th of June. We're now August. Would you believe that this boy's never seen the foster parents face to face ever since? That the department refuses to allow in-person contact, and the only thing that's happened has been video contact. since then? Now, members, is that a gentle approach? Is that consistent with what the magistrate says? That this be done in a sensitive manner, consistent with his needs, that it be done as a transition, that we make sure that we use school holidays to lengthen the period of time in which he spends with his maternal grandmother. What can be possibly said about this acting president? So not only is this judgment scathing, but the handling of this matter by the department afterwards raises serious questions. Now, we can't have then a situation in Western Australia, acting president, where the only place where those questions can be asked is in the parliament, and we've got the minister in the other place saying, sorry, can't talk about this matter because we don't talk about individual cases. So who's going to be accountable for this? Are we expecting someone then to have to raise a court case to bring it back before Magistrate Horrigan to say, you asked that this be dealt with in a gentle manner, in a sensitive manner, that it be done in a transition manner? Who's going to bring it to the court's attention? Not going to be the department, because they're the ones who have done this. Who's going to fund it? Are we going to expect the foster carers who are completely exasperated by this whole situation to do that? And then we've got a minister who won't even answer questions in respect to this matter. Something has to change, acting president, and if this case doesn't promulgate change in child protection, we're never going to see any change. We're going to continue to have the same cycle time and time again. Now, acting president, later in the judgment, the magistrate makes some complimentary remarks in respect to the maternal grandmother. Not surprising, given that the magistrate is ultimately approving of the department's decision to transition the care of this boy to the grandmother. At paragraph 233, the magistrate says, despite immense personal tragedy, NK remains focused on uniting her family, perhaps as a consequence of her significant losses. Her determination to recover her grandson, A, from Israel speaks to that focus, as does her dedication to caring for GA and DA and her participation in this hearing. Later, the magistrate says at 235, NK has satisfied the department that she is a suitable carer for KJA, notwithstanding his complex issues. Now, acting president, and so that's why, once again, I reiterate that the opposition is not critical of the maternal grandmother, and I would say, I'm grateful to know that this young boy has so many people who love and care for him and want to look after him. But my criticism is with regard to the department, the senior leaders in the department and the minister. And at paragraph 258, again, as part of this scathing judgment, the magistrate says delay is a factor which has worked against KJA's best interest. The plan to transition KJA 2 years ago at age 5 to promote KJA's long-term stability, consistent with section 9G of the Act, did not occur, and then litigation commenced. Hopefully the litigation will end with this decision almost 2 years after the transition plan was first mooted. Paragraph 277, towards the end of the judgment, acting president. The magistrate now, having assessed all of the evidence and all of the information that's before her, she starts to make her conclusions and findings, including having to weigh up these new provisions in the legislation that came in, if I remember correctly, in 2022. And so she says this at paragraph 277. Section 61(2)(a)(b) of the Act directs that the court must, in assessing the suitability of the proposed special guardian, have regard to the guidelines established under section 80 for a child of a culturally and linguistically diverse background, as if the order were a placement arrangement. I have already made findings in my decision about the carers and their lack of cultural engagement. While the carers are well placed to meet KJA's medical, emotional and development needs, the special guardianship order would not adequately safeguard his cultural needs in the long term. The proposed placement with the carers would not enhance or preserve KJA's cultural, ethnic and religious identity. As a result of this qualification, I do not find that the carers meet the requisite test for suitability applying the Section 80 guidelines. The consequence of this finding is that I am directed in mandatory terms not to make a protection order special guardianship unless I can be satisfied to the required standard of the suitability of the proposed special guardian. Notwithstanding the carers are excellent carers and love KJA very much, I find that they do not meet the statutory requirement under the Act. And then later, Acting President, in her final comments, the Magistrate says at 283, this is not a case of culture overriding the best interest of KJA. The Department is satisfied that the placement with NK is safe and that NK can adequately meet KJA's medical needs, which the Department will fund. NK will continue to be well supported by the Department. I'll just pause there for a moment, Acting President, because, as I said, this is a very experienced magistrate, and if there's one line in the judgment that I find curious, having read the whole thing, is this line that says NK will continue to be well supported by the Department. Well, the rest of the judgment indicates that the NK has not been well supported by the Department. In fact, multiple criticisms by the Magistrate in respect to that matter. Nevertheless, there is this curious comment made there. Goes on to say, KJA will also be eligible for a leaving care plan. The Department will be able to arrange contact with KJA with his carers, mediating relational strain and safeguarding KJA's ongoing connection with his maternal, family and cultural identity. Placement with NK would be consistent with KJA's best interest. It complies with the guidelines for placement within the child's family of origin. In compliance with my oath and applying the facts to section 61(2)(a)(b) of the Act, I cannot grant this application for special guardianship. And I can imagine at that point in time, Acting President, that must have been a devastating thing for the foster carers after all of this time to either hear or to read. And there's only two final paragraphs left in this judgment, judgment, Acting President. It's paragraphs 286 and 287, and they are headed recommendations. And this is perhaps, Acting President, where I am most critical of the Department. It says here at 286, I recommend, this is the Magistrate, having heard all of this, having just said that the foster carers who are loving and capable, I'm not going to grant you special guardianship, I'm going to instead allow the status quo to take place and for the Department to transition this boy to the maternal grandmother. The Magistrate then makes these recommendations. I recommend that KJA's transition be undertaken in a sensitive manner. Transition plans should include input from the carers and NK. In other words, from the foster carers and from the maternal grandmother. Consistent with the chairperson of the Care Plan Review Panel's comment, KJA needs all of the adults in his life to work together to help him achieve his potential. The Department has a solemn responsibility to KJA to preserve his relationship with the carers and their family consistent with the Section 9J principle. I recommend the Department arrange for KJA to have ongoing, regular contact with the carers and their family. Now, I'd like somebody, maybe the Minister for Child Protection would be the best person to do it. If not, maybe the Parliamentary Secretary newly appointed, Honourable Pierre Yang. Somebody can explain to me how that can take place, that the Magistrate can make those particular recommendations, and then I'm told that there's been no in-person contact since the boy was taken out of the care of the foster carers and put in the care of the maternal grandmother within a week of this decision. The Magistrate says, I recommend that the Department arrange for him to have ongoing, regular contact with the carers and their family. Acting President, I don't have control of these things. But if it was possible to do it, I would love to have the Department stand before Magistrate Horrigan today and tell her that how they've implemented that is through video messaging. Ongoing, regular contact with the carers and their family. Someone needs to explain what's going on here, Acting President. Is this the new norm for child protection in Western Australia? That we effectively rip this child out from his carers after 7 years, place him with the family of origin, and in the meantime says, yes, you can have video contact with the people that you've known as mum and dad. You're a 7-year-old boy. You've been with them since you were 4 months, and you can look at them on a video. This was in June, Acting President. We're now August. It shouldn't have to take the Shadow Minister for Child Protection to raise these matters. You know what's going to happen next, Acting President? You know what's going to happen next? I bet by the next time that we sit, someone in the department's actually woken up and gone, actually, this is not good. We better organise for this boy to go and see the foster parents. This is disgraceful behaviour by the department, Acting President. Now, above all else, this is why I said to members that I've taken the liberty of making this appropriation speech, because a significant thing had changed. See, when I gave my speech earlier in June, Acting President, on the 9th of June, all of this information and judgment was already there. That had been given 4 days earlier. 4 days earlier. But I expected, Acting President, when I turn up to the child protection hearings here on the 24th of June, some 19 days later. Now remember, Acting President, perhaps members aren't aware of this, the hard-working Standing Committee on Estimates and Financial Operations, they didn't call all of the Department of Communities on that particular day. No, they understood that this is a mega department. They said, we'd like child protection in on that day and we're going to deal with communities another day. So we've got then the Chiefs of Child Protection here on that day. It was the Honourable Jackie Jarvis who had the unenviable task of being the representative minister on that day, because she was representing on child protection at that time. And my first round of questions, Acting President, as Shadow Minister for Child Protection, was to ask about this case. Now, I genuinely did not expect that on that day nobody would know anything about this particular case. Now, no criticism to the Honourable Jackie Jarvis, absolutely none whatsoever. She was the representative minister and she's very busy with her own portfolios. How could she possibly be aware of this particular judgment? That I accept. That I accept. But, Acting President, this decision, remember at the time, it's only the second one in the Children's Court at the time, the defendant in it is the Chief Executive Officer of the Department of Communities. You know who that is? That's the Director-General. That's the person who was sitting next to the Honourable Jackie Jarvis at the time. Now, how can he not know about this particular judgment? What's going on in the department that no one told the Director-General anything about this? How can that be the case? Yet the minister thinks that she's got nothing to respond to. Not the minister here, the Minister for Child Protection at the other place. Doesn't want to answer any questions about it and puts up this facile defence of saying, no, we don't talk about individual cases. There's systemic problems that have been exposed by this particular case. The cultural plans that are put together by the Department in Child Protection are rubbish. That's my translation of what the magistrate has said, that they are rubbish. Now, if the minister thinks that they're not rubbish, explain it. Get the Honourable Pierre Yang, when he's next here, to deliver a statement on behalf of the minister to explain why Magistrate Horrigan has got this horribly wrong and how the cultural plans in Western Australia are magnificent. I'm saying they're rubbish. The magistrate is calling them inadequate, and she referred to them as meaningless rhetoric. Now, if you don't agree with that, if you're very proud of your cultural plans in child protection, deliver a statement in this place and rebut that, because that's what's on the record at the moment. It's not satisfactory. Yeah, ridiculous comment by the minister earlier in question time today in the other place, basically suggesting that, well, look, the magistrate has largely, I think that was her quote, if I remember correctly, I was watching it, largely sided with the department. Largely? Well, what about this? What about the parts that weren't largely supported by the magistrate? We're going to do something about that? As I say, time and again, Acting President, nothing is going to change if this is the level of diligence that is being provided in respect to oversight and governance in child protection. The whole case warrants a proper examination. You've got a court expert who says that the grandmother was not suitable, who minimised the child's medical complexity, did not understand his intricate medical needs. Court's made a decision, fair enough. Very difficult decision for the magistrate. I don't envy the magistrate to have to make that decision. And sensibly says that this should be done in a gentle and sensitive fashion, and yet the child is ripped out of the care of the foster carers and provided to the maternal grandmother, and then worse yet, there's been no in-person contact ever since. Now, Acting President, members will be aware that not only did we have this surprising episode during budget estimates on the 24th of June, when clearly not a single one of the senior leadership there knew anything about this particular case. Now, either they are at fault for not knowing about it. The alternative is that somebody in the department is at fault for not having briefed them. Has to be one of those two situations, Acting President. Well, since then questions were taken on notice at the hearing. The Honourable Representative Minister took those on notice, and then I lodged further questions on notice as part of the estimates process. And what becomes apparent, Acting President, I think rather startlingly, is that in response to the supplementary question, has the Minister been briefed on the judgment delivered by Magistrate Horrigan on JAH and ADH v CEO on 5 June 2026? Answer: the Department of Communities did not provide a briefing to the Minister for Child Protection on this matter. Why not? And is the Minister satisfied with that? Is the Minister saying that this is okay, or is the Minister saying, actually, I'm agitated about this, I expect better from the department in future, these type of scathing judgments I expect to be brought to my attention, including with a plan as to what we're going to do to make sure that this never happens again. Now, then there was an additional question that I had asked, Acting President, and I asked on what date was the Director-General, did he first become aware of the judgment? The date was the 24th of June. Now, members, that was the date of the hearing. So, in other words, when I first raised it in the hearings here, it was the first time that the Director-General knew anything about this particular judgment. And then I asked on what date was the Director-General first formally briefed on the judgment? 29th of June 2026. 5 days later, after I've raised this in a hearing, the Director-General is finally briefed. Meanwhile, no one's briefed the Minister. And of course, Acting President, in respect to the rest of my questions, you know what answer I received? Time and again, I received this answer. Quote, in line with the Children and Community Services Act of 2004, the Department of Communities does not comment on individual cases. How many times have we heard that? In other words, the department and those in charge of child protection think that they are immune from any accountability when it comes to child protection. Because if we follow their logic, Acting President, that means that every single answer to every single question that we ask in respect to child protection should simply say that. Sorry, we don't talk about individual cases. And therefore, we learn nothing. The Minister learns nothing, the department learns nothing, nothing changes, and we continue to have this aberration of a system that is the child protection system in Western Australia. And yet, here in this bill, we're being asked to fund communities to the tune of more than $1.8 billion. And so I ask again, Acting President, are we satisfied as members of parliament that this appropriation is not only appropriate, but are we satisfied that it is going to be administered under competent governance? After everything that we've heard, I'm not confident at all, Acting President. So I'm going to end, Acting President, there's only a few seconds left, to thank the foster carers in particular. I'm sorry to learn that they are exasperated. I'm not surprised at all. I thank them for their service, for looking after many children, and I do sincerely hope that the Parliamentary Secretary will draw this matter to the Minister's attention.